Morning.
Morning, Mr. Chief Justice. Your Honors, may it please the Court, on behalf of your appellant, Mr. Kris Ferreira, my name is Robert Galabois. This case arrives to you this morning by way of a conviction out of the Bristol Superior Court of a single indictment of unarmed robbery, and additionally from a split decision, the appeals court. If I may, by way of some background in terms of what the evidence suggested.
I know you can, but I think we've actually read what the
I don't doubt that you have read them, Your Honor. If you have a question, I stand prepared, I hope.
Well, let me just begin by asking you, you would say, I mean, obviously you are supporting Justice Milkey's dissent.
Very much so.
And so there, I take it, two reasons why you would say, before we get to whether there was a substantial risk, but two reasons why this was error. Number one, whatever might be the mathematical correctness of the analogy, or
yes.
not analogy, of the example used by the assistant district attorney, that's not relevant to the question of how sure the witness was, the
Correct.
complainant. And then the second is that it's sort of evidence. It's not correct, and it's really introducing evidence in the form of an argument. Is that?
Yes.
Is that?
Yes.
Sort of where we are.
His offering certainly was not based on any evidence that was offered during the trial.
Now, I was trying to find, was there any evidence offered during the trial as to what the source was of the photographs in the array? I mean,
No.
Do we know whether it came from Fall River records or from a broader database?
I don't believe there was any particular indication of where it came from, although I'm going through my head right now. There may have been some suggestion that it came from a Fall River PD type of database, but there was no other evidence.
You said it was people arrested and that was stricken, but that's all that I could find in
That
the
was
record.
pretty much the gist of it. There was certainly no evidence to try to establish what type of relationships may have been enjoyed by the people depicted in the respective photo arrays, and that certainly, as you may have noted, was picked up upon by Justice Milkey in his dissent, and the way it was couched, certainly in the statistical offering by the prosecutor during the closing. The fact that there was never any evidence suggesting what the relationship was between the other individuals in the array is certainly important to know before you start making any sort of statistical offerings.
Was there any, this is a subsidiary evidentiary question, but the attorney representing your client, wasn't you, right?
It was not me.
Right. In his argument said that and I guess the witness did, I mean the complainant did talk about, I think I looked at books that had 30 photographs or more. Was there any evidence of that, or was the only real evidence other than that these six array, the 2-6 array?
Right. There was actually a lot of confusion that's reflected in the record, I'd suggest. The victim says that he looked at 2 photo albums.
Right.
Upwards of 30 photos or more.
But was there any, other than what he said, was there any evidence of that?
He offered that, and the officer said, I offered 2 6-person photo arrays. Then there's further confusion, because at the trial, the officer acknowledges, he first says, these are the 2 photo arrays I showed, but then backtracks and says, wait a minute, this second photo array, the one that applies to your appellant, he was suspect number 3 initially at the police station, but somehow now he's depicted as number 1 here. So there was tremendous confusion, which was suggested by both the complainant or the victim saying, I looked at 2 photo albums, 30 pictures or better, and then 2 different 6-person photo arrays. But even when you talk about this, the second photo array apparently may be different from the one you actually showed on the night in question.
If I could turn to a different area, with regard to the questioning of Diaz as to whether they had driven in together,
Yes.
and whether they had lived together, is that, I know it's mentioned in your brief, is it an argument you make for reversal?
No, I just brought it to your attention to provide some background information. I'm acknowledging that the issue before this court, while certainly focuses on the statistical analysis offered in the closing, the underpinnings, obviously, of that statistical offering is based on identification. So I'm certainly suggesting that the identification evidence in this case must be carefully scrutinized, because that is what is the foundation for the statistical offering by the prosecutor during his closing.
Was there an objection to that?
There was not.
There was no objection to the questioning that he came in together and you've lived together for the last 2 months, when the reason they lived together is because
No,
they were
I
both
apologize.
in jail.
There was an objection, I apologize, as to the Diaz references. There was an objection. I believe there was an attempt by the trial judge to try to clarify or to cleanse it at that particular point, if you will. But in terms of the Diaz evidence, there was an objection noted. If I can, and again, identification is what is truly before this Court's consideration in context with the statistical offering.
No, finish your sentence.
Okay.
I apologize.
It's going to be a paragraph. I want to warn you.
Okay.
But,
I forgot something and I remembered it in my head, but you go ahead.
Okay. The victim says, I'm delivering a pizza. It's dark outside. And he hears the words to the effect, there he is. And after hearing those words, he's pushed from the back. So we know these two people are behind him.
I thought he was approached from the front.
He mentions, I am approached from the front, but then he goes on to describe, Justice Cordy, that I am pushed from the back. Says he goes down. In fact, he indicates that he has an injury on his knee, consistent from being pushed from the back. He says the first person is behind me with his knee on my back, and I am face down on the ground. And behind this first person is the second person, or the second assailant, who, under the government's theory, would be my client. He indicates, during this time, I don't get a good look at that second assailant. He mentions something that I can see his arm, and at best, the record reflects that he can see 3/4 of the second assailant's face. The assailants leave the area. That very night, within an hour or so, he is shown these 2 photo arrays or 2 photo albums. Certainly there's confusion there. The first photo array, he picks out that first assailant, the one that has the knee in his back, the one that's right behind him, quickly, and with complete surety, that's the guy. When he's shown the second photo array, he balks. And while he ultimately picks out the depiction of Kris Ferreira, he indicates that night, I'm not sure. That's also part of the record.
Doesn't he say he's about 80% sure?
He does. That's at the trial, Judge. During the trial, he says, when he's asked questions about how you picked out the second assailant and the second photo array, how sure are you? He started at 50%. He gets up to 80%. And that goes back to the night in question. But at the trial, and as you might imagine, there's the defendant sitting at a table. The victim's asked, do you see the second assailant in the courtroom? No, I do not. Not that he can't identify him. No, I do not. I do not see him. That was the evidence in this case in terms of identification.
Okay, but to be clear, you're not challenging the admissibility of the out-of-court identification.
Well, I certainly have some issues with conduct Lee, if that's what you're referring to, and how it was applied to this case. But under the status of the law, I can't.
Okay, well, I mean, you didn't.
The status of the law under Commonwealth versus Conduct Lee allows for the introduction of pretrial identification for substantive purposes. I'm certainly trying to suggest by way of argument right now that this particular case shows that that law has some problems.
Okay, but you're not suggesting that the photo spread itself was necessarily suggestive so as to be conducive to irreparable
No, I addressed
misidentification.
at the appeals court level, Your Honor, failure of then trial counsel, now disbarred, for not going forward with the motion to suppress identification.
So the only issue basically is the weight to be given to that ID, not its admissibility.
Correct. Correct.
If the assistant district attorney had, after defense counsel says, 80% sure, that's not enough, that's not proof beyond a reasonable doubt. If the prosecutor had said, as he did, you have to be 100% sure that he's got the right guy, and laid out the substance of what he presented in statistical analysis, but just said something like, you know, how likely is it that that the victim is going to pick out the guy I forget his name, the first assailant,
Pacheco.
Mr. Pacheco, and Kris Ferreira, and guess what? There's evidence that they're great friends. Blah, blah. How likely is that? And just hadn't done the 1 out of 49. Would you have a problem with that?
I certainly think it would have been fair game if he couched his closing in that regard, and he talked about inferences that you can be drawn. They knew each other beforehand, things of that type of sort. But completely ran afoul when he put a number to it. And if you will, in his closing argument, he himself, the prosecutor, talks about 80%. If you determine 80%, that's not enough, and that you need to get closer to 100%. He makes these remarks in his closing as he leads up to the bomb, if you will, at the very end. At the very end, that's when he comes up with this 1 in 7, 1 in 7, 2%, and then hits you. It says 98%. And right after that, he says the following: that's what I call proof beyond a reasonable doubt. Thank you. And sits down. That's how he concluded this case. So he's the one that argues throughout his closing, 50%, 80%, getting up close to 100%, that's where you need to be. And at the very end, he comes up with this statistical analysis and calculation that, candidly, or I'm offering for your consideration, just doesn't make sense. And he drops that bomb of 98%.
Well, I mean, to be clear, if there had not been this 1/7 times 1/7 analysis, and he has simply said that the judge will describe to you proof beyond a reasonable doubt, I say it's about 98%, and sat down, that would not be a miscarriage of justice by itself in the absence of an objection, would there?
I'd certainly suggest it would be. I certainly suggest it would be, Your Honor.
Because it's quantifying proof beyond reasonable doubt.
Correct, and it's well established under the cases I cited in my brief, Kelly, Sullivan, that we are to stay away from quantifying, and we are to limit it to drawing inferences from
right. It would be error,
evidence.
but would you say it would be error rising to a miscarriage alone?
When you put it in context, Judge, I would have to acknowledge.
That's, I guess, my point. I mean, if in isolation, it's one thing. It's only because of the context in which it's drawn that it's. I've proven it's 1/7 times 1/7 is 1 out of 49. That's a 2% risk, and
that's exactly right. You can't look at this through isolation. You have to put it into context. You truly do. And that's why I wanted to describe for Your Honors earlier, what was the identification evidence? And I'll concede, if you set aside all of the other evidence that was offered by the defense in this case, that is their criticism of Pacheco, and Pacheco got up there and said this was not Kris Ferreira who was with me, that was the co-defendant. If you set that aside, if you set aside Robert Diaz, who said it was me, if you don't believe him and set that evidence aside, if you set aside the alibi witness because there's a suggestion that you're friends with the appellant in this case, set all of that aside, go back and look at the identification evidence established or tried to be established by the victim. It's not there. It just simply is not there in this case. That's your context I'm respectfully suggesting. The suggested offering these calculations was undoubtedly persuasive. There's no question about that. I'm certainly trying to suggest to the court it was misguided. It was error as established precedent by this court. And it did create, undoubtedly, a miscarriage of justice when you keep it in context. See, I'm almost out of time. Any other questions?
Thank you very much, sir.
Thank you, Mr. Chief Justice.
May it please the Court, Rachel Eisenhower for the Commonwealth. The most important thing in this case, and it's something I actually neglected to emphasize in my brief, prior to any analysis of the effect of a statement in closing argument under the Kotek factors, a court has to determine what the content of the statement is. And I don't believe most cases go straight to the analysis. They say, he said this. Usually what the meaning of the statement is, it's obvious. And then they go straight to the Kotek factors. I would suggest that Judge Milkey, in his dissent, thinks that what this says is 1 out of 49, 98%, which is the equivalent of a satisfactory reasonable doubt showing, bingo.
Well, I tell you, that was my reaction.
And
so I wasn't a juror on this case, but it is a very superficially appealing argument.
that would be an improper.
And if an economist was there to explain to me why that argument makes no sense, then I'd be able to sort of discount it. But hearing it, geez, that's pretty impressive. 1 out of 7 times 7, 49, 49 chances out of 100, 98. I mean, that's...
It is superficially impressing in some ways, Your Honor, but what he actually says is, what are the odds that Mr. Gorse would have picked two different people, some other combination? 98%. Do you call that coincidence? I call that proof beyond a reasonable doubt. Now, what is that, and do you call that coincidence?
Well, are you suggesting that there's, you might interpret it differently, but it would not be unreasonable, would it, for a juror to interpret that precisely as proof beyond that? 98% is proof beyond a reasonable doubt.
The court would have to be satisfied, in order to adopt my reading, the court would have to be satisfied that a reasonable juror in context would adopt my reading and not Justice Mielke's. Absolutely.
Are you saying that it was a permissible argument?
No, because of the math error. The math is bad.
Okay. But apart from the math, was it permissible? I mean, isn't this a statistical argument? Was there a statistician who testified?
No, there was no statistician who testified.
So isn't he introducing an expert issue here through his argument?
I think the prosecutor believed that this was not expert testimony because
it's not what the prosecutor believed. Was it? Is it tantamount to an evidentiary statement that was not presented during the course of the trial?
Some math could be, and I think other use of math wouldn't be, for sort of a general rule statement. As for this one, I don't think this one rose to the level of an expert testimony because the level of combinatorics he's doing is 7th or 8th grade math. He explained it fully before the jury so that they could see his steps. And
but it's just to take the other side of that. I mean, there are issues that about, 1 out of 7, but is it really as probable, that 7th being that none of the above? Is that fair to be equal with the other 1 out of 6?
Oh, they're absolutely
I mean, there's a lot
equal.
of stuff that one would think an expert would have to testify to.
They're absolutely not equal probabilities. I mean, the majority opinion in the appeals court stated very well, this is not like drawing from a deck of cards, and it's not. His math is absolutely wrong. The question is, what would the jury have heard it as? Would the jury have heard it as this thing is a definite, or would they have heard it as his selection is heavily corroborated by the fact that these two people knew each other?
Okay, but the problem that I have with the case is he effectively is offering in evidence what is not in evidence, which is putting aside the photo spread in which the other defendant was identified, that the defendant did not also know the other 5 people in the photo spread. I mean, the co-defendant. I mean, we don't. There was no testimony that said, and he was on the stand. He could have been shown that photo spread and say, do you have any knowledge of who those people are? He was never asked. We don't know whether the photo spread was just a Fall River set of photographs, for which it's not that big a town. Similar age, I hope, of the photos. So isn't he offering in evidence a fact which is quite important to the math, and suggesting that this is the only person of the 6 who he knew?
Potentially, there's a reason I don't think that's a problem here, though. And that reason, he's clearly making an assumption without basis in evidence. But he never says, we know this is the only person he knew. He says, he sort of assumes it, but he never actually states that fact. And because of that, I think that the jury would be aware that he's making an assumption. And the other reason I don't believe that in this case that's a problem is because he very narrowly defines the type of relationship. It's not simply a question of whether Mr. Pacheco knew anyone other than Mr. Ferreira in the second array. The question is actually whether Mr. Pacheco and Mr. Ferreira actually have what I would describe as a brother-in-law relationship, even though there's no marriage involved. The one is the brother of the mother of the other one's child. So having defined the relationship as brother-in-law who carries the other one to an ambulance, even within a small community, 6 people of the same age, it's almost inconceivable that there would be 2 brother-in-laws in the array. So because the relationship was narrowly defined as, what's the chance that another one would be his brother-in-law, it would be far better.
Of course, if you narrow it, but I mean, there could be a guy he played football with in high school. There could be somebody who lived in the same street. Remember, you're dealing with persons of similar age, I assume similar ethnicities, arguably from the same middle-sized city. It's not that long. It may not be. I don't know where the set came from. The set may have been a state police set. I have no idea.
But that's not in evidence, Your Honor, to my knowledge.
So, I mean, that's the problem. The math is wrong. There are hidden assumptions there. Do we expect that a jury is going to understand that there are implicit assumptions there which are not in evidence, and therefore that he's making assumptions? He never used the word assumption.
He never used the word assumption, and that's unfortunate, Your Honor. I don't know if he recognized himself that he was making a logical assumption. He may have just simply taken it for granted that you would only know one person, that you wouldn't know the
if a
others.
smart, savvy prosecutor may have been under that misimpression, don't we need to worry that a smart, perhaps less savvy juror may also be making the same error?
Well, that's entirely a possibility, Your Honor. So.
What do you say to the point that Justice Milkey makes that in any event, none of this goes to tell you how sure or not sure the victim is about the photograph? I mean, that it's apples and oranges.
Oh, I think it is apples and oranges. I didn't read the argument to be directed to curing the 80% certainty. Rather, I viewed it as stepping away from the 80% certainty. Given that he's 80% certain now, are there other reasons we can nonetheless accept the evidence as a valid identification? And what he's assembling in order to make that argument is the old identification, which, as he points out, no uncertainty was expressed at the time it was made. That's from the officer's testimony. The officer says, he took longer making the second ID, but he didn't say anything about not being sure, according to the officer. And so what the prosecutor is saying is that, his memory is clearly less good now than it is then, but then there was no uncertainty expressed. So we can take that plus the corroboration of the fact that these 2 people have some sort of a connection, a close connection, and that connection combined with the prior certainty can form reasonable doubt. And he says, do you call that a coincidence? Do you call that sum of the evidence coincidence? Because a probability, 2% is not a coincidence, it's a number. So to have that question make sense, it would have to be referring to the sort of gestalt of the evidence. And is that evidence a coincidence? No, I call the sum of the evidence reasonable doubt. So that's a Commonwealth's argument, Your Honor. If there are any questions, the Commonwealth would rest on its brief.
All right, thank you very much.
Thank you.
We'll take a recess.